Hello, my name is Jay Chauhan. I am leading the group called Angel Mentorship Group, and today is the 25th of July, and I'm doing this video because as the problems come up in our mentorship group and we're solving real files, I am looking into the question of how to use specific legal concepts in the daily life. And very often when you're studying law, it is not taught in the fashion of how to apply that law in a practical situation. So we have two situations, one in the corporate law and one in litigation, where the question of what is the release came up. So I'm going to reply that to not only those persons dealing with the file, but also to the whole group there. And I also want to include in this group also sometimes the self-represented litigants who are engaged in doing their own litigation need to understand these legal concepts as well. So today's topic is the subject of what is the release and when do you use the release to conclude certain events in the legal system. So first of all, a release is a document based on the law of contract in which you terminate a legal action, but you're also terminating the cause of action by an agreement with the opposing party and saying that in exchange for the consideration that you're paying, you will be releasing your cause of action, your right to continue the action. So typically, the release is provided at the end of litigation if it is a settlement, and also in some other situations, for example, in corporate law, where there is no litigation, but you have, for example, shares in the company and you want to sell the shares. If you sold the shares to another person and you have a position in the company as a director, as a shareholder, or as an employee, then you have the rights to dividends, your right to vote, etc. And if you sign the release, you are terminating those legal rights by the release. So it is important that you have a release at the end of an event in which you terminate your proceedings, if you like, or your right or a cause of action, so that the parties know that that you're no longer proceeding to enforce that particular legal right that you have. It's called cause of action in the law. So if there are two parties, you would have what is called a mutual release. If it's one party paying another party, then you're paying what is called consideration, and the other person says that in exchange for that money, you're going to release that cause of action or the right to bring that action for that amount in the court. So when you have a lawyer engaged to try to draft a release, you'll see that the language is very convoluted actually. My own opinion is that it is more important that you draft the release to identify the cause of action rather than take a precedent with very fancy language and try to use it and twist it around to try to accommodate your particular situation into that wording. So some of the wording, I think that which is sounds complicated to the lay person, is still necessary to ensure that the cause of action is properly terminated. So very often you'll see the wording like your heirs, assigns, and so on. All those wording is there so that if the cause of action is transferred or sold to somebody or assigned to somebody, those people also do not have a right to bring an action, because as I mentioned to you, that the principle of the release is found in the law of contract. So your contract is with another person, and the contract always has identifiable parties. And so if the cause of action is assigned to somebody, you will also terminate the right of other people to use that right instead of you. So I think that the magic in the wording is what you terminate as the legal cause of action. So you should, as a lawyer, identify this one. If you're not a lawyer, try to understand what is the right that you have and identify this in the release, and then you can say that you are releasing it. So usually it's about half a page or so, and you use the right wording to ensure that the resolution of the matter is properly done and that there is no risk to the people to go back into the court system to have it resolved. So that is the message of the day. Hope you keep an eye on our Angel Mentorship group, and we'll soon be doing CPD programs. If you have any comments, please write them below. And if you're interested in CPD programs, we will announce them on the Facebook, and you can contact our office to attend these seminars. Thank you. See you again.